Hello everyone, I feel very happy to be once again back and to continue the discussion on fundamental rights. Today we are going to explain the core portion of part 3, that is the different rights that are promised by the Indian Constitution to the citizens of India, starting from Article 12 till 35. So I welcome all of you to my 6th video on the Indian Polity lecture series. So let me quickly introduce what are the different rights available to Indian citizens under Part 3 of the Indian Constitution. First, we start with right to equality, Article 14 to 18. Then we have the right to freedom, that is covered by Article 19 to 22. And right against exploitation is been mentioned in Article 23 and 24. And next we have the right to freedom of religion, perhaps one very comprehensive religious freedom and rights been covered under Article 25 to 28. And then next we have the cultural and educational rights covering Article 29 to 31. And last we have the right to constitutional remedies, that is taken care of by Article 32, but goes until Article 35. So Article 33, 34 and 35 also forms part of the Indian Constitution fundamental rights. So we will also be discussing on those 3 rights. So these are, in short, there were 7 fundamental rights earlier, including the right to property, but now after right to property being removed, we have only 6 fundamental rights. So let's start. To understand rights, we need to first understand Article 12 and 13, because throughout fundamental rights you'll find mentioned the state. So state shall not, state will not, state will provide. So the word state is always used. So here the definition of state. What is state? So Article 12 of the Indian Constitution tries to define that definition of state. So here it has 4 parts. So the first part is all the executive and legislative organ of the union, the central government, in one hand. And next we have the state government. So I've also mentioned all the executive and legislative organs of the state government, and also local authorities, municipalities, and goes on till the village. So any organs which enjoys the power of the government or the governing or administrative powers. So it can also be statutory or non-statutory authorities like NHRC, that is National Human Rights Commission, Life Insurance Corporation, PIL, SAIL, etc., etc. So even goes even to the extent of private body or any agency of private which are working as an instrument of the state or of the government. So anybody, it may be a private, but if they are if they are an instrument assisting the state or the government, they all can become under the definition of that state. So the state, the scope, but the definition is very wide. It is bound to cover a lot of those areas. So starting from the central government to the state government to the authorities at the local level, that is municipalities and panchayat and village level, to even statutory and non-statutory authorities, and even private bodies which are working as an instrument of the state. So remember, these Article 12 definitions are very comprehensive. So these actions, it is the action of these agencies or the institutions that can be challenged in the court if those actions are violating the fundamental rights. So what we can conclude here is that Article 12 has a very wide coverage and it has a very broad application of the definition of the term state. Article 13 defines what law is. So here Article 13 says any law which is inconsistent with fundamental rights can be reviewed by the judiciary. So I've just written here JR, that means judicial review. So if the state has passed any law which are violating the fundamental rights of the citizens, then what happens is that the court, the Supreme Court or the High Court has the power, has the authority to strike down such law because they are undermining the citizens' fundamental rights. That is what we call it judicial review. And for the information, only the higher court, that is the Supreme Court and the high court, has the power of judicial review. So district court and municipal court or village court does not have the authority to pronounce judicial review over fundamental rights. So Supreme Court under Article 32 and High Court under Article 226 has the power to strike down any law if such law is harming, undermining, affecting, taking away the rights of the people. Now, Article 13 also has four provisions. The first one is the pre-constitutional laws, that is before 26 January 1950. So the commencement of the Constitution was 26 January 1950, but even before that, we had certain laws in India. So those pre-constitutional laws, if those are found to be contravention to Part 3, undermining the provisions of the fundamental rights. Remember, not all the laws of the pre-constitution, but only those pre-constitutional laws, those are undermining, affecting citizens' rights, will be declared as null and void by the Supreme Court. And post-constitutional, that means after 26 January, one is before 26 January, whatever laws that we had in India, if those laws are harming citizens' rights, Supreme Court and High Court will strike it down. Now the next is, after the commencement of the Constitution, 26 January 1950, to present if the state is making any law trying to harm fundamental rights of the Indian citizens, the Supreme Court, the High Court can strike it down. And state cannot make law violating Part 3 of the Indian Constitution. Article 13, subclause 3 has given the real definition of what law is. So whichever items will include as a character in the character of law. The first one is permanent law or the ordinary law, which is enacted by the parliament or the state legislature. So parliament is the temple of democracy. They are bound to pass law from time to time. So any of those passage by the union parliament or the state legislature will be considered as law here. Second is temporary laws, or called as an ordinance. Can ordinance be resorted to judicial review? The answer is yes. So if the parliament is not able to pass the law, maybe because of any reason, the war going on between India and any other country, or maybe because of any natural calamities or any crisis, that any reason that parliament is not able to have the session and pass the law, then it's not like the route is closed. It's not like there's no other alternate for the government to pass the law. There's a way. If the parliamentarians are also not able to pass the law, the government can still make use of precedent. So president can do what parliament cannot do here in this circumstances. So president can pass the ordinance which has equal impact or equal power like the ordinary law, just that the duration can be temporary only. Otherwise, efficiency and effectiveness, ordinance and permanent laws, they are more or less they are equal. So can be issued by the president or by the state legislature during crisis or during emergency situation. So this ordinance can also be termed or can also be considered as law under Article 13 definition. Now, anything to do with executive orders, notification by laws, rules, regulation of the state, of the government, can also be considered as law here. And non-legislative source of law, such as custom or usage, having the force of law. So these are very comprehensive once again. So Article 13 has given 4 definitions of law. So in short, what we can say is every action of government. So these are all, the state or the governments in action. So the actions of these will be challenged in the court if these laws, any of these laws, permanent laws, ordinance, executive orders, notification, custom or usage, if all of this is harming the fundamental rights of the Indian citizen, then the court can challenge such law and the court will not allow such law to take place, will be declared as null and void. So what is missing here is constitutional amendment. So this is one very critical reality of this Article 13, that Article 13 missed out Constitutional Amendment Act. So here constitutional amendment is not law under Article 13 definition. So what the Union Parliament can do is, Union Parliament, by making permanent law, if they're not able to undermine or make any changes to the fundamental rights, they can still amend the Indian Constitution and maybe modify the laws which is in Part 3 of the Indian Constitution. So this is one limitation of Article 13. Now let's start with the rights under the Indian Constitution, Part 3. The first right available to Indian citizen is right to equality. Now this right to equality is mentioned, explained under Article 14 to 18. Now Article 14 is one of the most popular articles. So it has two keywords. So these keywords are, you can always remember, equality in before law, equality in law are the keywords of Article 14. So let me read for all of us. The state shall not deny to any person. Now see, person is mentioned. So for the information, throughout this fundamental rights, there are two words are used. One is person is used here. The word is person. So person means anybody. It can be citizen, it can be non-citizen. Aliens are also, foreigners are also included. They can make use of Article 14. So any person here. But in some articles it is mentioned citizens shall, citizens will. So remember, those articles are citizen-specific rights. But here this Article 14 is any person, so including citizens and non-citizens can also make use of Article 14. So the state shall not deny to any person equality before law or equal protection of law within the territory of India. So the purpose of this Article 14 is very clear, that to establish rule of law. So here the framers of the Indian Constitution has taken the help of two very important constitutions, British Constitution and American Constitution. First, the equality before law is a negative implication which the framers have taken from the British. Next, equality, equal protection under the law is an American positive implication which is taken from American Constitution. Now there are some differences between these two. So equality before law wants to emphasize that absence of any special privileges favoring any section of people or anybody. So equal subjection of all the persons to the law of the land. So it regardless of rich or poor or high or low or official or non-official, nobody is above the law. So in India, the constitution is the sovereign and supreme law of the land. Everything, everybody, every institution comes under the Constitution of India. So this implies perfectly the rule of law throughout the territory of India. So next is equal protection under law, equal treatment, and equal under equal circumstances. You go to court, the court will give you two, punishment or reward. So when doing that treatment, you have equal treatment. Law doesn't have two standards, one for the rich, one for the poor, but every subjects needs to be treated equally. So here it says equal protection under the law. So this implies that in India, throughout the territory of India, the rule of law will apply. The Supreme Court held that Article 14 is a basic feature, and therefore the spirit of Article 14 cannot be destroyed even by an amendment of the Indian Constitution. Article 15 prohibits discrimination, and here the state shall not discriminate against any citizen. This time it's mentioned citizen. So remember, Article 15 is citizen-specific rights. So this cannot be enjoyed by the foreigners. The state shall not discriminate against any citizen on ground only of. There are 5 very clear and specific mentioning of those grounds. That is, religious-based discrimination will not be allowed 100%. That is a big no. and racial based discriminations, or caste, forward caste and backward caste, caste based discrimination, discrimination based on gender, you know male or female, place of birth, because that you are born in some backward areas, northeastern region, or you are coming from a village, you are born in a village, so discrimination based on your place of birth. So these are just in very brief, these are not allowed. This discrimination based on this five specifically mentioned this ground, this area: religion, race, caste, sex, and place of birth. Discrimination is not allowed by the state to any citizen of India. So there are two crucial words here: discrimination and only is also mentioned. That means discrimination on other ground outside this five mentioned, it may be allowed. And if that happens, then the court may have limited jurisdiction to protect your rights. So it may be based on age. For example, age is not mentioned here. So if there's a discrimination by the employer on the employee in regard to age, then the court may have limited authority, or the court may have limited jurisdiction and may not protect your rights based on the age. So what is to be important is the discrimination should be based on any of this mentioned five criterias. If that is discriminated on based on this, court will definitely, Supreme Court or High Court, making use of the appropriate articles, can come to your rescue and your rights can be given back to you. Article 16 wants to bring all the citizens together under one frame. That is, it wants to provide equal opportunity in matters of public employment. So it is public employment, that is government job and not private. So it says equality of opportunity for all citizens. Remember, this is another citizen-specific rights. So equality of opportunity for citizens in matters relating to employment opportunities or appointment to any office under the state, that is government office. So no citizen shall, on ground only of, again, there are certain grounds that are mentioned here: religion, based on religion, Hindus or Muslims or Sikh or Christians or Buddhists, whatever it is. So that based on the religion discrimination, or racial or caste or gender or descent or place of birth or residence, or any of them. So these are the mentioned grounds that equal opportunity to compete for public employment should not be denied based on this already mentioned grounds. So if you are discriminated based on this, then the Supreme Court can intervene and the matters can be solved in your favor. Article 17 abolishes untouchability throughout the territory of India. So the enforcement of any disability arising out of untouchability shall be an offense. Now this is declared as an offense which is punishable in accordance with law. So in the year 1976, Untouchability Offences Act 1955 was amended to expand the scope. Now the laws have made more stringent. It is 1976. The Untouchability Offences Act also strengthened the rules and regulation, now making it very tough for anybody who is promoting this untouchability will be severely punished under the law of this 1976 Protection of Civil Rights Act 1955. The 1976 amendment has broadened the scope of Civil Rights Act of 1955, and they have introduced certain sections. First one is preventing any persons from entering any place of public worship, denying access to any shop, hotels, or places of public entertainment. So that will be amount to practice of untouchability. Refusing to admit persons in hospital or in educational institution or hostels which are established for public benefits, So anybody is doing that, then it amounts to practicing untouchability, preaching untouchability, and justifying untouchability on any ground, that is traditional, religious, and any other grounds, will also be amounting to or tantamount to preaching or promoting untouchability. So it will be penalized and the punishment will be there for such crime. Article 18 abolishes titles throughout the territory of India, and it says, sub-article 1 says, no title except military and academic distinction can be conferred under the Indian Constitution. So no citizen of India can or shall accept any title from foreign state also. So this is done to ensure equality throughout the territory of India. So if any citizen avails title from foreign countries, then he may elevate his social status, thereby creating inequality. So this he might manipulate those status. So it is now very clear that no citizens shall accept any title from foreign countries or foreign state. For aliens also, if he is working under the central government or the state government, he is not supposed to, without consent of the president, he is not supposed to accept any title from foreign state. Now this is in connection to loyalty. So it might he becomes susceptible to foreign influence, and even the division of loyalty is there. So if you are conferring certain titles by some foreign state, then you might develop loyalty to that country. So if you're serving in India, then you must serve the interests of India only. So a lot of 100% dedication is required for any foreigners who are serving under the profit or trust under the central government or the state government. So you cannot, without the permission's consent, cannot take any title from foreign state. So it goes on even till present or emoluments or office or any of this from foreign state. So these are made very clear for questions of loyalty. So these are what Article 18 have prescribed to both citizens and non-citizens. Only civilly, there's a military and academic honors can be conferred under the Constitution of India by the President of India. So even hereditary titles or nobility such as Maharaja or Rani or Raj Bahadur, these things are nobilities which are created during the British Raj. So these creations are not based on merit, but they were based solely on loyalty. So those Indians who are loyal to the Britishers were created. This class were created by the Britishers to serve their colonial interests. So it undermines the principle of equal status of all. So after 1950, we have put a blanket ban on those identifications. So hereditary titles or nobility of any kind has been stopped by 1950 Constitution of India. The theory of equality does not restrict identification or recognition of merit person in the society. So in the year 1996, the Supreme Court upheld the constitutional validity of the national awards such as Bharat Ratna, Padma Vibhushan, Padma Shri, or Chakra awards. So these are not titles, but these are just an honor conferred for their exceptional service. So should not be used as suffix or prefix, which is made very clear by the Supreme Court. So national awards, which got instituted in the year 1954, was discontinued once in 1977 during emergency by Janata Party under the prime ministership of Morarji Desai, which was revived in the year 1980 by the Indira Gandhi government, and which is continuing even till today. So these are not to be taken as titles, but these are just honorarium or honor because of your extraordinary service to India. Under Part 3, the right to freedom that is between Article 19 to 22, is the second right that is mentioned in the Indian Constitution Fundamental Rights Part 3. And Article 19, right to freedom, is one of the most popular of all the freedoms. So under Article 19, they have given actually 6 freedoms that the citizens can make use of. That is freedom of speech and expression. You can include freedom of press also, right? RTI, right to information, are all linked with freedom of speech and expression. Here we are not giving a critical analysis of fundamental rights, but we are just presenting the merit of articles. So today we are not supposed to be criticizing on Article 19, right to freedom, right to equality. Those criticism part I will make another video. So next is freedom to assemble peacefully without arms, freedom to form association in union, and freedom to move freely throughout the territory of India. The logic behind this is that the entire territory of India is one for the Indian citizens. So freedom to reside also and settle in any parts of the territory of India. And when it comes to, again, practice of profession or occupation or trade or business, citizen have absolute freedom or liberty to choose based on his talent or his interest. So Article 19 is very controversial also. It is very interesting also, and it has granted 6 very crucial freedoms to the citizen of India. Article 20 protects criminals against arbitrary and excessive punishment. So under the Constitution of India, punishments are not prohibited, but allows to be exercised, allows to be presented to the criminals with due process of law. So under Article 20, the first one is ex post facto law. I'm not reading the content of this ex post facto law, but what we can understand is that individual should be punished only if he violates a law which is an active status during the commissioning of the crime. Next is that it should not also have a retrospective effect. So the law which is made in 2025 should not punish a crime that was committed in 2024, because during that 2024 there was no law. So a new law which was created in 2025 only should not be able to punish the crime that was committed earlier. So these criminals which have done crime in the past cannot be covered by the new law. So it should not have a retrospective effect. So very clear that first important thing that we need to understand is that person should be punished only when he violates a law in force. Second, even when he is punished, is that the punishment should be such that it should not be greater than what is prescribed by the law in force. So that is the first one, ex post facto law. The next is that no double jeopardy. So see, the language are very technical. So that is why Constitution of India has also been criticized for using a very tough language. These are very all technical, ex post facto law and double jeopardy. These are it's too tough for an ordinary Indian to understand. So these are very technical languages. So throughout this constitution, these technical terms are used. So here, no double jeopardy means no person shall be prosecuted and punished for the same offense more than once. So the law cannot give you 2 sets of punishments for the same crime. So you should not be receiving any 2 types of punishment for the same crime. So this is what Article 20 wants to safeguard criminals. Article 20, subclause 3 has the word self-incrimination. So no person accused of any offense shall be compelled to be a witness against himself. So in more simple term, no criminal should be forced to confess or short should be forced to submit to his crime. So, of course, it does not include compulsory production of material objects or compulsion to give thumb impression, signature, and so on and so forth. This doesn't amount to self incrimination, but in case of any evidence or proof, the criminal should not be forced to submit to his crime. Article 21 has two keywords, that is life and personal liberty. It says no person shall be deprived of his life or personal liberty except according to procedure established by law. Here the definition life and personal liberty has been expanded. Today Article 21 is one of the lengthiest articles of the Indian Constitution after its tremendous expansion by so many in a lot of occasions, like 1950 Kopalan case, or 1996 Jamili Singh versus State of UP, or in the year 1976 Menaka Gandhi versus Union of India case. So in all of those instances, the Article 21 has been expanded. So here the word life is not just about living life, it should be living with dignity. And their life, right to life, should be accompanied by right to food, right to decent environment, right to education, right to medical care. So if any of those items are not provided, then the Article 21 is denied. It's amount to denial of Article 21. So your life gets affected. So India, life is not just about living, but it is living with dignity. So even personal liberty during this Menaka Gandhi versus Union of India case of 1976, personal liberty includes also right to privacy. So you have the absolute right to privacy, right against solitary confinement. So if you are imprisoned in a solitary confined, it is amounting to affecting your personal liberty. So it may also be turned down by the court. Right against custodial dates is crucial, is very inhuman way of handling the criminals. So this is also another important thing that the court will turn down. And right against handcuffing also affects personal liberty. So if you are ready to cooperate, you are not supposed to be handcuffed. So because why handcuffing is applied or resorted to only when you are not cooperating. So all of this affects personal liberty. So Article 21 makes sure that secures your life and your personal liberty under the Indian Constitution. Article 21A, right to education, was inserted by Amendment 86, Constitutional Amendment of 2002, and a new fundamental rights were inserted. Right to education. The state shall provide free and compulsory education to all children of age 6 to 14 years is what has been promised by Article 21A. And Article 21A was before under DPSP, Directive Principle of Set Policy, under Article 45, which says the state shall endeavor to provide early childhood care and education to all children until they attain the age of 6 years. So from DPSP, it has from non-justiciable rights, it has become a justiciable rights under Article 21A. So it also has consequently inserted one fundamental duties in Article 51A. So right of children to free and compulsory education under our Right to Education Act of 2009. So it is now the responsibility of the parents to send their kids not to work but to education. So instead of working, the children's at the age of 6 to 14 years. So any children of India that is coming under 6 years to 14 years are not supposed to be working in any factory, any industry, anywhere, but they're supposed to be learning. This is the stage of learning. So this is one very important rights extended to the Indian citizens, Article 21A, and consequently there is a duty also that parents or guardians are responsible to are answerable if they are not sending their children to school, and they're answerable for that. Next, we have Article 22, which reads protection against arrest and detention in certain cases. So there are two, that is punitive detention and preventive detention. So under punitive detention, this is normal. There's no problem, because if you are convicted and after going for a fair trial, and if you are convicted by the court, then there will be certain punishment, so no question. But here under preventive detention, this is detention without trial and conviction by a court. So you may get arrested, or you may just by suspicious. So this is during abnormal time. So one is during normal time, and the other is during emergency or during abnormal situations. So here, to the purpose of this preventive detention is to prevent someone from committing an offense in the future. So it may be prone to misuse by the law enforcing agency. So it is precautionary measures which may be based on the ground of suspicious. So very controversial, that you may sometimes get innocent people also may be arrested and put into certain difficult situation by sheer suspicious. So if you're not talking properly, if your walking style is suspicious, they may even be arrested. Under these articles, there are two things as mentioned. One is that he has already committed a crime. So the consequences will be that he will be convicted, he will be imprisoned. But the most controversial is the preventive detention. That there's an identification that he is potential for crime, or potential to commit a crime in future. So this sort of identification is under preventive detention. So preventive detention is done before the crime is actually committed. So this is just precaution measures to prevent somebody or someone from committing a crime in future. So actually, this is a very unmindful sort of power been given to the law enforcing agencies, which are bound to be misused, and in fact has been misused a lot of time in India. So with this, I come to an end of my first part. We will start with Article 23 in my next video. Until then, it's a very good night, and thank you for watching my video.